Given that, is the Constitution a living document, open to interpretation, or is it something that must be read strictly and adhered to regardless of the day?
You know, Scott, that is the question that is asked constantly of judges. There are some things in the Constitution that are black and white. You can't, except during times of war, the government can't quarter troops in people's homes. Now, even in that black and white situation, what is the meaning of quartering troops? If there is some sort of war effort going on in the United States, and the government knocks on your door and says, our guys have to go in there for an hour and reprovision themselves or use your bathrooms or do something like that, the courts may be asked, is that quartering troops? Is that a constitutional violation? There's always that sort of twist in what happens. And then there are provisions that are very general in the Constitution. You can't have an unreasonable search and seizure. What does unreasonable mean? What's a search and seizure? On those three words, search, seizure, and unreasonable, law books are filled. Shelves and shelves of them are filled. And so to talk about strict interpretation or living constitution, those are not words I use. And they're not words that I think have much meaning, because what you are doing is interpreting new facts to an established law that in part has been given meaning and precedent, and that in part has a historical background. And you're drawing from all of that toolbox of precedents, history. Some of my colleagues don't rely on history, but others do. And from statutory construction principles. It is not about reading words strictly or about living constitution. It's about giving meaning on the basis of facts that are presented to you.